Our next presenter, Manny was here last year at this meeting, but Manny, I've got a little blurb for Manny. American Business League was founded by Manny Lopez in 2012. Manny's a longtime business owner, and he's a former senior investigator for the Wage and Hour Division. And Manny now has his own company called American Business League, in which he's consulting and advising growers. So, why don't you help me welcome Manny?
Can everybody hear me? I was a drill sergeant in the reserves for like 19 years, so if you can't hear me, I always tell everybody, I don't like to use that. If you need me to use it, just raise your hand and I'll be glad to use the microphone. I appreciate the invite. I was here last year. I have so much to cover, and I only have like 45 minutes to do so. But what I want to do is what Karen did today, that's like a 3.5, 4-hour presentation. So the only way she could have gone through some of the more critical things was to miss a lot of that. And so I'm glad that she did that, because I could touch base on some of the things that I would just go through really fast. I will cover some other areas and maybe go into some details on transportation. I know a lot of your questions are going to be what rights. I'm going to go into a lot of what your rights are. And I am also going to go into how to prepare before Wage and Hour gets to your field, what to do, what's their thought process. And then secondly, while they're there, what can you do not only to protect your company, but to make sure that the investigation goes smoothly. Doesn't mean that you're right. It could be there's some problems. That's not a problem. I was an employee, remember. So I absolutely believe in the Wage and Hour Division. I would have been very angry if Rudy, who was not my boss at the time, actually during this whole time, but he was one of our supervisors, if he'd have come to me and said, you know, we're not paying you this week. See, we'd have fought. I have bills to pay and everything else. So I absolutely believe there's a need for the Department of Labor. The other part of this is, normally when I get to work with business owners today, and I notice when they ask about raising hands and all that, and I'm telling back, I'm talking to my son, I said, they're not going to raise hands. Normally when I get to work with you after now, because I'm now trying to help you, because regardless of whatever anybody ever says, there's nothing better at protecting yourself than being in compliance, following those regulations that they talked about. That's it. My job is to go in and make sure you're following those regulations. That's what I do. The only difference is that you're more apt to probably speak a little bit clearer, more openly than me. And I appreciate that, because once we get you into compliance, there is a statute of limitations that applies. And so every month that goes by, once we visit you, if you use me to come in and check you, every month that goes by, after 2 years of the statute, if Wage and Hour comes in, you're in compliance. There's no civil money, because Wage and Hour realistically goes back, actually I understand now they're going back 3 years in case there's willful. So they're reviewing record for 3 years. My entire career was normally 2, unless we realized that there was some actual bad stuff going on, then we'd go back 3 years. They have the right to do that. We're going to talk about some of that stuff today. I just want to, on just a couple of things, I want to try and clarify, give you a different perspective on, or a thought process on seasonal workers, because that was one of the questions. And a seasonal worker could work. You can have somebody who works 12 months a year. If they go, and forgive me if the crops are out of the way, but if they go from berries, and then all of a sudden down they're pruning afterwards, and then afterwards they go to grapes, and then they prune, and then that is all seasonal work. They could be there 12 months of the year. That's all seasonal work. They got to be doing non-seasonal work. Tractor driving. They got to do stuff that you don't need crews to go do. If they're doing more of that, then and some of that, they may drop out of the record or out of the position of seasonal worker, the definition. But that's where it goes. Is if you have workers that come in and they're working year-round for you, just because they're working year-round for you doesn't mean that they're full-time workers and it doesn't apply to them. Does that make sense? So you got to look at your crop base. Seasonal is defined by the crop base, what they're actually doing versus the time period. Secondly, let me see, one other thing I wanted to talk about. Oh, we are on my website, the www.americanbusinessleague.com. We are putting as many forms as possible on there. We have a fact sheet format that we're putting together. Hasn't been added to it, but hopefully within the next couple of days, you'll be able to get on access, and these are going to be the fact sheets that the Department of Labor has. There is the transportation fact sheet. It's a 4-page fact sheet. It talks about the insurance. It talks about the weight. It talks about the CDL. It talks about it all. So you'll have access to that on the website. So you can just go on there and print them. And you know, it doesn't cost you to go onto our website. You know, a lot of websites might say, hey, you need to just go on there and you can just look under resources. I think it's what is it going to be titled? It's going to be under resources, and you'll be able to download the form for the minors that are 12 years old. If they're going to work with their parents, they're going to be on there. And so we have some. I just want to give you those kind of heads up for our part. I'm going to go through fast. I'll be around afterwards if you have any questions. Here's what I did. I worked for 30 years. I was with the government for 40 years. Before, I know my son didn't put up here, but there was an 8-year stretch there that I worked with the Department of Agriculture. I was a technician with the Soil Conservation Service. So, and I was hired as an investigator under MISPA, the Migrant and Seasonal. So I was in ag most of my career, with the government. I've always enjoyed working around agriculture because it's summer versus tree planting and tree thinning, and sometimes it gets cold up in the mountains. I was a typical investigator. I'd go out and visit. What I found out, though, many, many years ago, was my supervisor that hired me asked me, he said, you know what, if you go in and do this, and you might not like an individual, they may piss you off, excuse me if that offends, but can you back off if you know that they meet the criteria, just because they make you mad? And I said, you know, because back then I was a young drill sergeant, and you get stubborn. I said, how many have been in the military? How many of you still love your drill sergeant? So I was really, how can I? Well, here's the deal. You got to be willing to back out, because what he taught me right off was there's regulations. There's guidelines that we have, and you need to be able to follow those. And as soon as you do that, if it's against you, get out. So never put yourself in a position where you can't back out. And I kind of lived with that. I was very good at, when I did an audit, I would go, and if I found back wages, and I did, I don't know, maybe I've even audited some agents, where I found back wages due, and I'd look and say, here's what I found due. Am I missing something? I mean, are we missing the exemptions? Are we so when I left, or when I left the company, it was all, we went through all we could possibly go through to make sure, and then I could say, how many you owe? And it became very good for my career, because today, now that I'm retired, I got people who I've collected point blank $200-some thousand who call me, can you come and help me? I said, how? Well, because when you left here, we felt comfortable. And I think that's the role that we need to play sometimes when we deal with businesses. So anyway, that's a little bit about me. This is what my company does. I speak at industry conferences like this. Yesterday I was in Reno speaking to some firefighters, and then as soon as we were done, we're driving on, and my son said, oh, I'm so glad you're driving. I said, that's okay. We're going to go up to sleep a couple hours, and we're going to go up here and talk to the caneberry growers. We're going to do this. One-day group trainings, I hold this. What Karen did today, I do that in a 6-hour period. I do 4 hours MISPA, or FLSA, MISPA, then sometimes you have H2A workers, but there's also other criteria, how to prepare for a wage hour audit, how to prepare at the audit, how to be ready for at the audit. So we do all that in a 6 hours. So we do those kind of trainings. On-site friendly audits, notice we put friendly. You do get, when somebody comes in with a badge, that works. I mean, people get intimidated. And I'm sure that's one of the reasons why they wanted to make sure it's official. Regardless, whoever came up with the idea, you had to show. I actually, you know what, most of the time I show credentials, a picture, rather than the badge. Very seldom. The only time I ever came up with the badge was when somebody started giving me a hard time. I said, well, they do have some authority. And we'll talk about that authority. So we'll go do audits. I'll do exactly like wage and hour. I'll come in, I'll do an initial conference, I'll interview your employees. You will not get those interviews. Those interviews are confidential, just like wage and hour. In fact, most of the time I'm taking notes. I am not going to put them down in writing. I'm not going to make them sign. I just want to know. And then that way when I come in and I do a final conference at the end of it all, you guys will get exactly what I found. The only difference with me doing it versus waiting until wage and hour comes in there and preparing is I don't charge liquidated damages, civil money penalties, and the back wages, when we come up with back wages, it's going to be up to you realistically whether you want to pay them. I'm praying, I tell you what, I think the average investigator in the Department of Labor, 200, maybe 250,000 in back wages a year. Last year, through the American Business League, we collected about $800,000 in back wages that were paid out. Because your people are saying, well, what do we owe? Did we wrong? Yeah, you're wrong. Here's what should have been paid. You want? Here's a 2-year period. And we put that all out to you. And I really do, because I'm a former employee, now my own business person here, I enjoy doing that because we're collecting. But we're doing it on, I think, the way that probably should be done. There was a lot of things that I think the big one. Investigative support, if you're being audited, you can call me. And then we go over some of that stuff, and we know the requirements that are necessary out there, and that's all we want to do is say, are you right, are you wrong? I went to one the other day and said, yeah, they're making me pay overtime for this. Okay, you owe it. But they're asking me to pay this one. You owe it. What do you want? I gotta go. You don't need me here. You owe it. Don't pay. You don't know why you're gonna pay me. You owe it. And then he goes, well, can you check the computations? I said, okay, let me check the computations. And they had been asking, this was state, so I was not fed, so I'm going to do this. I said, let me check their computations. And they were making them pay time and a half when they should have been half time. So it went from 150-some thousand, I recalculated, about 37,000, but you owe it. So I'm able to help you in those kind of situations, maybe to touch base. My job, because I know how to do the computations, I do is more to verify some of the stuff. Wage and hour is pretty accurate in most cases what they're doing. So, we're going to talk about how much you argue, how much you don't. Then, you know what, the investigations have been going on for years, they're going to continue to go on. The best thing, of course, is compliance. So that's what way you do as ABL. The Department of Labor does have the right. They have a right under the Secretary of Labor to go onto your property to review. We'll talk about onto your property in a minute. To go and look at your records, to do an audit. I mean, they can do everything. They can interview employees. That's part of their regulation. That's a federal regulation. You as a business owner, when you say I want to be a business owner and I'm going to do this, you have given them those rights. You don't want the rights? Give up the farm. But they have the right legally to go onto your property. Okay? They have the right to inspect your records. Now, I want to clarify on the 72-hour thing. That's very clear that your property, if you have it on, obviously you're not going to have records on the fields. But if you have them in your office, that's the 72-hour notice is if it's in a different location, like at a bookkeeper. If it's not, your office, if it's all your records are there, that's considered the same location. They have the right to look at those records that day. That day. You don't have the right to delay them. And I'll say that carefully because we'll talk base about how on some of that. But they have the right. Those are their rights. They have the right, collection and payment of back wages, if they're due. The assessment of civil money penalties, liquidated damages, assessment of liens, possible litigation. It all goes part of what they go the further they go down to into their investigations. They have those rights. And so I just want to make sure you understand it. They have those rights. But you also have rights. Actually, but here's the protocol guidance, and I kind of put them all, this is for me more than any of you, but there's 2 books that we're going to talk about today. The Code of Federal Regulations is the actual law. What makes me probably a little bit different than an attorney is that with 30 years and in conducting investigations, I've learned that what has happened, like with the Code of Federal Regulations, period. Nope, this black and white, that's what the law is. Your attorneys know those. I heard saying is always, a good attorney knows the law. A great attorney knows the judge. So, I'm kind of the other step here. You guys can know, your attorneys can know the law. My job is to come in and say, there's guidelines that the national office has put together. They said, you as investigators are given these guidelines. Because how many, in the law, are there any lawyers in here? The laws can be very tough. to try and interpret. So what the national office has done is they came up with a set of guidelines and said, we're going to provide you, if you have any questions, here's how you follow. And I understand those guidelines, and they're very critical because there are some complicated things in there, and we want to say, and we want to give you one of my best examples that I do. The federal law says, or CFR says, if you work 40 hours, you're due overtime. Period. Now let's say non-ag at this point. Non-ag, you're due overtime. However, our guidelines will say, you know what, if you're a daughter, we're not going to collect that. That's not going to be something we normally collect. So if you find a daughter and we're doing an investigation, say, of a restaurant, then we know that. The problem is you don't. And that's, I think, where most of our conflicts are coming in, where the authority is what you have as rights to do. Because these books that have been given guidelines by the national office are very clear that they cannot change this unless there is written policy from the national office. So, as an investigator for many, many years, I have learned and tried to follow those because that's what they're there for. It's how I interpret when I go into a case. And so we're going to talk about that kind of stuff. The district director, I put Rudy's name on here. I didn't even know who was going to be. These are our district directors in the Portland office. And since we're in this area, those are the two supervisors out of the Portland office. Jeff Jenkins is the district director. He's in charge of the Portland district office. Regional, national, we have coordinators like our MISPA coordinator. I don't know, who's the MISPA coordinator?
Ruben Lugo.
Ruben Lugo. The enforcement coordinator, he deals with all the enforcement. That's Richard Longo. He was on the front. He's the one who puts together those slides and makes sure that the laws are enforced accordingly. The regional administrator, Ruben Rosales, I know Rudy from California probably worked with him before he even moved up here. Ruben was the one who taught me and trained me how to do MISPA. He was a MISPA specialist for many years, and now today he is in charge of the entire area. He's a great guy, really. Not that common, Rudy aren't. And then, of course, you have your national ag coordinator that changes. That in a lot of these cases, when they go on to a MISPA case, the investigators, they are coordinating all of this stuff. And we're going to talk a little bit about this. So the national office sometimes is pretty close tied in with, especially when you're dealing more with H2A, H2B type of cases. They're going to be wanting to know what's going on. And when you deal with ag, probably more on a regional level. What's the process? Somebody asked about complaints versus targeting. 99% or so of the cases that we're going to get in agriculture, I mean, first of all, they're not at liberty to disclose which way. You got to protect the complainant if there is a complainant, so they're not at liberty to disclose, so they're not lying to you, they're telling you the truth. They don't have the right to disclose that. They're not at liberty to do that. But I can tell you that about 95 to 99% of the cases are what we call directed, meaning we sat out. Wake and Hour we put out 5-year plans. And when I say they put out 5-year plans. Agriculture is always a priority. If you've been involved in agriculture, you've probably heard of the Department of Labor. That's a priority because of a lot of actions that have happened in the past. Agriculture, there are some problem areas sometimes, and we need to be involved in it. We will always probably be a priority area for us in the Portland District Office. It's always going to be a priority. So once they do that, so you know about that, so you can eliminate the question about, hey, is there a complaint? Most of the time, probably isn't. What normally happens is they'll come through and they'll say, they're going to be there right before the investigation. We prepared. They're out there with binoculars. They're looking to make sure. Once we start seeing the red boxes out there, you can depend. They're probably out there trying to figure out when's a good time to go out and target. And I say target because that's what we're doing at that point, at industry, is we're going to go out and look. And not only are we going to look at that, we're going to try and find out when the workers go. And as the workers start coming in, then they come in as a group. No, it used to be just a couple, but sometimes now I guess they're coming in with 7 or 8 or even more than that. I mean 15 at one time, where they come in and do audits. They bring in people from other areas to come and help them with these field inspections. So they're surveying. There's a lot of surveillance involved in this, and that's the prep work of it. Before that, then the other thing is then they do the field visit. When they come and do the field visit, what normally will happen is they will do the field visit, but they've already followed a vehicle probably to where you're processing, where you're dropping off your berries. Because they want to know if they find a problem, who they need to speak to next. So this is all their process. So it's nothing out of the ordinary. They would probably do that, I would imagine, with the garment industry, whatever it is, because when you're establishing for hot goods, you've got to be totally prepared for this. They come in and do an initial conference. That means they're going to have to establish coverage. Here's the problem, and one of the problem areas is sometimes they'll go on the field without establishing what the coverage is immediately. And I know one particular field where they used hot goods and it was not covered. And so the people were on hold for one full day before they said, well, you know, you're exempt from the hot goods. Because hot goods only applies to the Fair Labor Standards Act, which meant they're either shipping them out of state, or did they meet the exemption of 500 man-days in this case, or were the workers local workers? Were they exempt from the laws? And so you got it. One of the things that I always recommend is, and why when they say what rights do you have to be on the field, I would try to push to make sure that they understand, and they understand, to establish jurisdiction first. That's what coverage does. It establishes whether they have even jurisdiction to be here. And sometimes that jurisdiction, they establish it by being out in the field and making some errors. Where's the crop going? Where's it going? So some of that does include some investigative process. Okay? If I'm not going to just go because somebody said I have 500 man-days, I would go in there and find out and make sure, show me the records. So that you understand, so they could still go on and go, I'm not covered. No, they're going to have to prove that. It would be really bad for Karen as an investigator to say, yeah, they're exempt. Yeah, they're exempt. And all of a sudden, while we're telling them, they say, hey, we're exempt. No. They have to do the research themselves. So, but that's good to establish that. Interviews, parts establishes that. Records check, it establishes that. I put down here, apply all exemptions, because another area that we need to be worried about, you as growers need to be worried about, these exemptions, they may have jurisdiction, but there's times that there's some exemptions that apply that I have been involved in, and they missed them. And it's just that when you're out there, you're asking questions, and sometimes you just fail to ask a question. Blame it on me, I did it too. You're trying to get out there and you're seeing 100, 150 workers, and then our bosses are saying, you need 20% interviews. Oh my God! Oh, and you're going through as fast as you can, and sometimes you don't ask the question. But you guys are in a unique position, because caneberries, blueberries, a lot of you have, and I'm going to talk about the exemption, but I'm going to bring this one, you have a lot of workers who come in just during the caneberry season. If there was anybody who didn't like their parents during the summer, that was me. Cutting apricots. I hated it. But I know I didn't work more than 13 weeks, and that was back then when the song The Band of Gold, because I remember just singing the band. How many remember the song The Band of Gold? I remember picking up my mom at the end of the year. She said, you know what, it cost me more to feed, because I made, all summer I worked and I made $15. And she said, this ain't going to happen again. So she told my dad, we're not going, it cost me more to feed them. All they do is run and play and sing songs. And so, but there are some exemptions for those kind of people that come in locally who all they want to do is make the food, get the money for, sometimes for their clothes and all that. Those are exemptions. Local workers, it doesn't matter what age, if they work less than in agriculture combined, 13 weeks a year, then they're exempt. You don't have to, you can pay them whatever you agreed to under MISPA protects it, because MISPA, remember, is agreed to pay. Okay? That MISPA doesn't have a minimum wage. All it says is you've got to pay what the applicable minimum wage. And if they meet an exemption for feds and they meet an exemption, well, first under MISPA, you got to understand there's for federals and states, you got to understand, I'm talking feds here. So yeah, unfortunately you have some of that meets both federal and state. So if they're meeting that exemption under federal, then that exemption applies, they aren't. And there's going to be a lot of you that will have it. So Karen said it, there is a piece of paper you can fill out. It's on our site right now. You can fill it out so that, it's not, I don't know if it is. Yeah, I have that, I think it is. Where you can say, if you're a local minor or a local person, not minors, just any adults, not anybody, working less than 13 weeks, you've got to ask those questions. And then you file. That is some protection. The other exemption is, yes ma'am.
Is when you say working less than 13 weeks in agriculture, does that mean specifically for me, or does that mean me and Susie and Joe and Bob? You, Susie, Bob, Manny, anybody. So we have to ask them that. You are obligated, yes. And Karen's saying, you got, one of the things you have, whether we like the paperwork or not, you decide you want a business, there's some things that go with it. That is very, very critical. Okay, so you have to make the initial effort to do that. If you have a farm labor contractor out there, probably those guys are not going to be in the 13-week exemption part of it. But if you're hiring, or if they walk onto the field, that was one we had in past where they walk onto the field, and I'm seeing them, auditing them, and interviewing them, I'm thinking, and of course I'm seeing
and I don't know the name, Kennewick Wrestling. I've seen so-and-so cheerleader squad. And I go to the investigator and say, make sure you ask about the 13-week exemptions. I think these are a lot of kids from the local school. And of course they got mad at me. I wasn't trying to be, I was trying to make sure you ask this. And they got mad at me, all right, but then I heard them go and talk to them and say, make sure we ask this question. And so those kind of things you should tip them off, and you need to, it should tip you off too. Because as you pay them and it works. So anyway, so that's the other exemption. We'll talk about it. And I just wanted to let you know your job is, if you don't know the exemptions or don't have somebody there to help you during one of this situation, then you're going to be at whatever mercy that you get. Because they don't, if they miss it, not intentionally, if they miss it and you don't know it and they haven't talked about it, and all of a sudden they ding you for not paying overtime or minimum wage property because this guy or gal made $6 an hour instead of $7.25, or in the state of Oregon, 8, whatever it is.
9.10.
What is it now?
9.10.
9.10. So who's asking about $10? Pretty dang close. So anyway, and then of course you always, once you get the audit and you get it done, reinvestigations are a big thing. They will go and spot check to make sure they have the right. That's part of their situation. Establishing coverage, we talked about 2 coverage, $500,000 and individual coverage. But you notice, if you're making less than and every law stands by itself. So under the Fair Labor Standards Act, if you're making less than $500,000 a year, if the individuals where it comes in and they're manufacturing a product that is going in interstate commerce. So if you manufacture berries and you're delivering them within state, not to the processors, because processors send them out. We're talking in-state to, we used to grow watermelons when I was growing up in the Yakima Valley. Watermelons, cantaloupe, everything else. And our delivery spot was Safeway. So that is not interstate. That's intrastate. In that case, individual coverage may not apply because you're not going through it. Did that make sense? It's got to be product that they're working on that's going to go to it. So if you take all your product to a processing shed, then it's going to go, more than likely it's going to go interstate and individual coverage applies. Exemptions, the 500 mandate. Yeah, somebody asked about, is that true? Yeah, it is under the Fair Labor Standards Act. The 500 mandate is applicable to a farm labor contractor. Under MISPA, it is not. So your 500 mandates, you include your workers and everything else, and the farm labor contractor could be exempt under the Fair Labor Standards Act. But under MISPA, they aren't. It doesn't apply. Non-local minors we talk about, local, non-local. Minors, migrant and seasonal workers, so long as the kids are 12 years old, 13 years old, 14 or 15 years old, 12 and 13 with permission slips. The rest of them, the Department of Labor is not here to say, you should not ever say, you shouldn't have kids out there. You know, I would have said it when I was younger, when Mom wanted me to take me to work, but that's not the case. The case is they can work, so long as you meet the criteria. The criteria is very clear. If they are migrant kids, which means they are away from their home overnight, then so long as you're paying them on a piece rate basis, the same way that you're paying the regular adult workers, piece rate, keeping the records, separate records, they're not picking with somebody else, they're doing everything exact, they're exempt from the law. They're exempt from the minimum wage. That make sense? So don't be afraid just because you have minors. A lot of them, oh man, we can't. You can't. Got a lot of these families travel with their kids. And so, but you got to match it with states, because Washington is a little different. Washington is like you got to pay 80% of what the state minimum, it was, because I work in both states, and starting to do some California, really right, that's a weird state. They've got some really tough stuff down there. So most of California is like tougher than the wage and hour division. It's just a tough state. But in Washington, for kids, forget what I just said, because their state laws are different. And even in Oregon, you got to look and see if there's any differences, because Oregon could legally say, we don't want kids in agriculture. And then no matter what I say, you can't have kids in agriculture, it's a violation. So unfortunately, you got to look at state and federal law. But in Washington, I think what we ended up is a state of Oregon or Washington that said, you're welcome to use kids, but you got to pay them 80% of the minimum wage. I think is what the last thing we looked family, small businesses, sure. If you are the ones doing all the hiring, because you're small enough, you do all the hiring, recruiting, soliciting, all the fresh tea, that's what it's called. If you do all of those and you don't allow your foreman to do what Karen says, make the calls, make sure they're here, and all they're doing, they're allowed to call the foreman, hey, when are we going to get started? That's not recruiting or soliciting, okay? But once you start utilizing them together, then now you have to, you lose the exemption. You're exempt from the law otherwise, which happens to a lot of the berry growers. They meet this criteria. So you got to remember that. DOT versus DOL, the whole thing I want to add to this one is, if you are more than 75 miles round trip from where you're going at any time, then you follow DOT regulations. If you are under that your entire time, then you follow DOL regulations. And those forms are also on our site, so you have access to those. And that's just the main thing, because DOT is a little stricter. Carpooling criteria. All right, let me spend some time here. Carpooling is a tough thing. You cannot in any way, as a grower, be involved. If somebody's going to take all their cars to the field and go, that can be legal carpooling. That's as long as you're not controlling it. Once you start actually controlling them, tell them, hey, we need 5 workers here, can you grab them? Bring, all of that now brings you into where licensing requirements, farm labor contractors, the licensing, all of that starts working with it. When you have vans, most of the time what Wage and Hour will come in and do is if they come in and see fields of vans or 2 or 3 vans, they're automatically looking. And I'm just telling you this so you don't get up. I would look too. They're going to look and see who's driving, who coordinated that, how did it go, because those could potentially should have been licensed as farm labor contractor or farm labor contractor employees. Because there are some people out there, all they do is transport. That's all they want to do. So they'll find the workers that come, day workers that come and hang, and they'll pick them up and bring them. That's contracting. So the carpooling part of it, again, staying apart from being involved with it. Sure, you're ultimately responsible in case Wage and Hour comes and says, we're going to consider that non-carpooling transporting. If they do, you can ultimately be responsible. You know what? Here's the end result. When you deal with a farm labor contractor, in the 30 years that I have been an investigator myself, personally working in here, automatic, if there's a farm labor contractor, we're going to make you responsible. I mean, it's very simple in most cases. I cannot remember a time, even though we as investigators sometimes argued with our supervisors as pre-rooting counsel, have said, whoa, they're not. Yep, we're going to count them as a farm. They know about the farm labor contractor. They're not. So they're not meeting it. Doesn't matter. So take it from here that no matter what, if you hire a farm labor contractor, they're going to tell you that you are joint employee. And how far you take it is up to you, depending on if there are no violations and everything. Who cares? Does that make sense? Sometimes we jump at it right away because they say, "Oh, they're joint employment." Well, do we have any problems? No. Okay. Call it what you want. So long as I don't have any problems, I don't coordinate on. So long as there's no problem. But joint employment is established right away when there's a contractor. I did that for years. That was an automatic. Oh. How is ETA? I'm going to just give you this. I know that don't raise your hand, but in case you know somebody who does have some housing, here's Wage and Hour is obligated that there's housing that is before. Now you're going to make me remember this. May 3rd to oh my God, May 3rd. You remember what date it is for ETA versus OSHA? 19. No. Oh my gosh. Anyway, if it's older housing, May 3rd something, 2003, I can't remember. But they are obligated, because some housing is developed under ETA regulations. And then anything newer than that, they've got to use OSHA regulations. But they're obligated to ask you how old your housing is so you know if that leaks, because a lot of the housing, if it was under ETA, is less square footage per person. So you got to, if you have housing, you want to talk about that, call me and we can talk about it, or talk to me afterwards. But there's 2 regulations: ETA, employment training, and then there's the OSHA standards. Anything before the date that I'll tell you later on, if you want to ask me, we have it. Operations. Here's how you prepare for an audit. Kind of separating this a little bit. The operations. You identify. When we're going to talk about hot goods at the end here, but hot goods is a 30-day stay. They can say your goods are frozen for 30 days. You are unfortunately in a tough situation because sometimes your crops won't last 30 days. So, but if there's any way they can, I know I talked to somebody earlier about making the crops of what they were growing into juice. That may be able to hold, you know what I'm saying? So there may be situations where this will work. Identify a temporary storage place where you can just say, okay, hot goods, I may not be able to ship them, but I'm going to store them, and then you can continue to pick in compliance. Identify in-state merchants. I mean, that's what we did with Safeway. You can do the same thing. You can have somebody say, hey, I got a great deal for you. I've got this many crops. You want them, I'll sell them, and then go to different. That's a good way to protect yourself. So what I'm saying with this is, remember, this is prepare yourself ahead of time with those merchants in your area so that you might be able to bring them some deals if this ever happens, depending on how much is being held. Establish good faith. Here's the good faith. Good faith just means you cannot bury your head in the sand. Coming to stuff like this association, you better thank them because you got to be a part of this. You've got to go through the training. You've got to go through sometimes self-audits. Sometimes it's working with your processing places. I'm dealing with, I'm going to be working and doing some training on some processing sheds because they're obligated also to say, hey, if I'm going to accept this, I'm going to make sure you know the laws. And so all of this is good faith. What good faith does is it allows you sometimes to be able to say, hey, you know, we're doing everything we can. We've done this, we've done this, we've done this. And sometimes, out of the grace of the courts, they might say, we'll eliminate. In fact, I think sometimes that can be even afforded to you by the Department of Labor themselves, because they are in charge of their civil money penalties. So it's what you're doing as an individual farm, as a grower, as an association to help yourself to try and stay in compliance. Paydays, 14 or 15-day intervals. Here's the thing. Somebody asked a question about the how often with minimum wage. The fact of the matter is, if you pay on a daily basis, you got to make sure everybody is paid minimum wage at the end of the day. If you pay on a 14 to 15-day basis, and I'm not saying to change, this is just one of my techniques that I would do. If they've gone through 5 days and they're $20 under minimum wage, but the payday is still 10 days away, whatever it is, you're not in violation yet. The violation doesn't occur until you have made payment. So they could make $10 or $3 an hour one day, $15 another, and so long as they're above the minimum wage, that's okay. That is absolutely okay because you're not in violation until you've made the payroll. So if you pay every day, yeah, you've got to check every single day. That's part of the law. You have to pay them, you have to bring it up, everything else. What would be good faith? I was dealing with somebody the other day, or actually the other summer, who'd been audited, and he showed me a bunch of cards in the middle of the thing. Now he had about, I'm going to say just under 300 workers out there. But there was a stack of cards like that on the table when they were paying. I said, so what is that? He goes, well, those are people who didn't make minimum wage. We're paying them the minimum wage, they're fired. I said, can I do that? Yes, so. They've got to make minimum wage, you're paying them the minimum wage. So he's updated and fired. Another thing on good faith. He said, and you see this card right here? We found a lady, her husband didn't make it in, so he sent the wife in to pick on her card. Now, she's picking on her own card. Probably realistically wasn't a violation because it was a card and she was tracking everything. But he said, nah, you need to get your own card, and fired her. So we can't be picking on your husband's card. We're going to do it right. So those are little things that you've got to tweak in your operations, how you handle it when you're dealing with farm labor contractors, what you demand of them. Remember, they work for you. Okay. Managers educate, no trespassing signs. They have the right to come on. They do have, under the FOH guidelines, they have to, but our guidelines, remember the CFR? Our guidelines are very clear that they need to get permission from a person of authority before they interview or conduct an inspection. So what do? First of all, your farm labor contractors are not people of authority. That is not their property. You hired them. So you need to make sure that your farm labor contractors know they don't have the authority. I don't care that they're their people, they don't have the authority to put them on the property. Only the owners or whoever you have assigned as the authority that you have. Does that make sense? So when I inspect farm labor contractors, I tell them, you don't have the authority. You don't. It's not your property. And you need to make sure that if you're going to use farm labor contractors or a foreman that's out there, what authority you're going to give them or grant them for the wage and hour to come on property. One thing per person, have employees clock in. Always, the time cards are critical. Karen's right. Ruben Rosales, the regional director, told me one time, we're going to give you all the rights and all the time in the world to make sure your records are right. If you fail to do so, you're putting it in our hands. And they go out, and they're supposed to establish by interviewing and all the basic stuff. That's wage and hours responsibility. So you've got to make sure you do it. Lunch breaks, obviously. Third party, time studies. Time studies should be done no matter what. Time study means that you are going to, as soon as your workers start, it takes 1 hour. Pick 5, 6 workers, make sure, and pick your slowest workers, don't pick your fastest, because you probably know some of that already, and just time them for an hour and see how much they're picking for an hour. That makes sense, because you want to be able to establish where you're coming per pound, because what's happened in the past with the investigations is they're arbitrarily coming up with a number. And when they arbitrarily come up with a number, you're stuck with that. So how you have to do is you protect yourself is by doing what they should be doing or have done to verify, to offset some of that. Okay, so don't do your fastest, do your slowest. Make sure. And I would do it in the morning, I would do it in the afternoon when it's tired, just to make sure. But most of all, if you're paying them and you're keeping track of the hours, even though they're on piece rate, which you're supposed to do, you'll be able to tell if they're not making a minimum wage anyway. Pay them correctly. But it's just a way of supporting you. All right? During the night, call a representative. You have an association. You have some of you. How many of you belong to the Oregon Farm Bureau? How many of you belong to felons? Tim is one of the best attorneys. I am telling you, he is very good at dealing with wage and hour because he knows the regulations, what you're legally entitled to. You have the association who might have their own attorney. The main thing is, it's not something I would do without an attorney. You have the right under our FOH guidelines to request an attorney to have a present or a bookkeeper at the investigation. You have the right. What does that mean? When they're on the field or they come and say, yeah, listen, I've got to get my attorney, it's going to be 2 hours, come on here. They can wait. They can wait. Because you have the right to have that attorney as a citizen of the United States of America to have an attorney. Heck, they give criminals, you have the right to, and you're not a criminal. So you should have those rights. And so you have the right. Our guidelines say they should give you that right. And now, obviously, you're now dealing with, if you're saying, well, my attorney's out of town for a week, there might be a different interpretation here. We're talking about being able to get it because they do have the right with their authority to go in and do these things. So the whole idea is to be able to work with them on that. I know, coming here. Here's the thing, when you're on the field, once wage and hour comes on there and they're ready, before they get the permission or whatever they're doing, what you need to do is, first of all, count your workers. We got to eliminate this ghost worker stuff. This ghost worker stuff is when they come up with numbers because they got an arbitrary number and all of a sudden there's 300 extra workers that didn't get there. The workers that they don't find, here's the policy of the Department of Labor. They have 2 years in which to find unidentified workers. And after 2 years, guess where the money goes? General fund. So ghost workers, the only way you eliminate them is as soon as wage and hour is there, start counting your workers. Take a head count, bring them all, make sure they've got individual cards. And what you want to do is you want to continue at that point in compliance because hot goods only applies to products and goods that have been produced in violation, minimum wage overtime record keeping. I'm sorry, minimum wage overtime and child labor record keeping is not a part of it. That's why I said, if in 2 weeks comes up, if you're paying 2 weeks and they come here and they say we have a violation on this, we haven't paid, then you're not in violation because you haven't paid it unless you have child labor. That's in violation. So take a head count immediately. Go make sure everything is in compliance and then separate the product that's already been picked in case they come in and say that product's been picked because a worker says, here's this, here's that. So you want to separate. You have the right, just like they do. They carry video cameras, they carry cameras. You have the right to video record that stuff. Just don't, you know what, don't mess with the interviews. Interviews are very confidential. That's why even with mine, my role is you leave the employees alone. And when they say, I want to take you out there, no, show me, give me the directions. I don't want you to know who I talk to. It's up to me. And the employees we have to protect. Okay? Employer rights, legal counsel, schedule interviews without disruption. Tim's very good at that, but again, they have the right to do it. That doesn't mean that you can't try and work something with them. Doesn't mean, because they can bring them out to lunch period. You can work with them so long as you're not interfering with the interviews. We talked about record keeping. Oh, this is one thing. When you're dealing with hot goods, what they do is they go contact the process, and the guidelines are very clear. They say that you do have the right to be a part of them contacting the processing. Anybody above you, you have the right to be involved in that process so you know what's going on. Now, the problem with the CFR or the FOH is only 33 chapters are on the internet. There's 89 chapters. So these guidelines you're not aware of. I know because I've been involved with it for so long. And so the unfortunate thing about it is that if they don't give you that or don't advise you of that, then you don't know it. My boss told me right off, my boss Tom, when he said, man, why do you always have 2 hours of training time on your 40? I said, I've done that all my career, Tom. He goes, no, tell me about these 2 hours. I said, I broke down my guidelines and my CFR. I broke them down in just individual chapters. And I made a point to I looked at them, I studied them. And I always recommend to the new investigators, you got to break them down, because if you look at a whole book, I mean, our books we got 3 books like this. I feel sorry for you guys, because that's just wasting an hour. But if you look at a book and there's 30 pages in a chapter, you can take an hour or two of study, and that's basically where we were at. Oh my gosh. Summary of back wages. Once you are given a summary of back wages of the 56, you have the right, because you want to verify if they're correct, if they're back wages, you have the right, according to the FOH, to request a copy of the computations. I always recommend that. They've been denying it, but you have the right under the guidelines. You can, and I would always recommend you do that in writing. First ask the investigator, and normally they don't do it. Yeah, they should. And if they don't, and that's because they can't ask you to pay $40,000 or whatever it is and say, trust us.
Yeah.
We're good to go. They shouldn't do that. They should be able to say, here's how we computed. And they're going to say, well, we verbalized it. No, verbalize. I want to see. And that's where I come in, and we can ask it. But you don't need me for that. That's something that you're legally required. I mean, they're obligated by the FOH to provide you. So don't be afraid to ask for those things. And of course, don't sign in. I was looking at the BCES, they're called forms at the end. You're asked to sign those. If you look at that very carefully, it's the same thing that happened with the hot goods. They're saying, if you sign this, you're waiving every further right to lawsuits or anything to protect what you've got. And I'm looking at that, they say, I got to include this in mine. And because it was one of those things that I didn't pay attention to. As an investigator. And now I'm looking at that, and it does say exactly the same stuff. So you have to decide whether you're signing stuff or not. If you want somebody to review it, you got the American Business. Give me 2 minutes.
Wrap it up.
Okay. Employee rights. This is a very important one, and we have a form on our site. Employees also have the right to say, I don't want to be interviewed. That's all part of it. You don't interfere with that. They have the right. They can say, yes, I want to be interviewed, or not, no. But they have the right to say, I don't want to be interviewed. They have a right to their own counsel, just like everybody else. So they have that. And here's the big thing. They can also have the right, before the interview is started, to request a copy. You don't have that right. You can't tell them. To ask for it. That's none of your business. That's up to them. That's their right. I come in and I'll talk to them in a training mode, just when they're bringing me in to trade, and then we provide them the paper so that they know they do have these rights. And that's for them, not for you. You don't get copies of it. That's not for you. Because that's not good. You don't want to do it for you. All right, I am done here. Basically, Karen's is a 2 hour, 3 hour, and I think I cut out all that stuff. Karen did it for me. But anyway, here's what we're going to do. We're going to be putting some training together. We're going to get with Tom, and we're going to do, so you get to know about hot goods. You get to know about all this stuff. And it probably will be before harvest, hopefully. So within the next month, we're going to do some training on that. We'll make sure, I hope you do attend it, because some of the hot good stuff is very critical stuff for you.
But you've got one coming up, I know, in Southwest Washington.
Yeah, we have one in, what day is our one in?
Richfield, March 18th.
And they've asked us because they've been hit several times, several years in a row.
And just for full disclosure, this is your business, and that's a fair amount of charge on that. So why don't you tell folks what the charge is for that?
Manny?
I believe it's $200. It's $200 for the individual. If you have a company, you know, if you want to bring your bookkeeper or whatever, it's $300 for the company to attend.
And we will be going, just so no, Karen did, that's what we're talking, we're going to go, but we'll go into some details with that. But it's knowing the regulations and then knowing also how to prepare for the audit. Okay?
We'll get information over to the you guys.
To Tom. So we'd love to have you. And that is what date?
March 18th.
March 18th, and it's going to be at the Pizza Pizza, right off the highway, right off the
Yeah, exit 14, I think, right there. Right, George? That's
yeah.
going there.
So we'll, oh, the Ridgefield exit. Okay, thank you very much. You know, good luck this year. And let me give you my number, 541-912-5826. Manny Lopez. And don't get that confused from my son, Manny Lopez. Thank you.